Does my house have to go through probate? Hey there, my name is Ron Payne, and I'm the CEO and managing partner here at Payne Law. And a question we often get from the loved ones in a family when somebody's passed away are, does the house have to go through probate? Or if we're doing the estate planning side of things, is my house going to have to go through probate, especially if that's the only asset? And the answer is no, it doesn't. Now, there are times you might need it to go through probate. You might want it to go through probate. However, if you are not planning to sell the house, if you're just leaving it to your heirs, and if there are sufficient funds in the estate to cover the bills that exist, you don't even have to take the house through probate. It will not even pass through probate. So the way that would work is, let's say you've left the house in your will to your kids equally. You've got 3 kiddos, and you say, when mom and I both pass, you're going to leave it to them equally. So you've both passed, and they're getting ready to look at it. If they're going to keep the house, let's say one of them's going to live there, and the other 2 are fine with that as long as they pay the taxes or whatever, and so they're going to be co-owners, and they're going to live happily ever after doing what they do. Then as long as there's sufficient assets in the estate to cover any other bills that might come up, maybe last medical bills, the funeral bill, that sort of thing, or if there's only a small amount of bills and if you really want to keep the house and so everybody gets together and says, hey, we'll take care of the small bills, that way we can keep the house, then you don't have to do it. It can't be brought into the estate. The only way that a house has to go through probate is 2 reasons. One, you are looking to make sure, like you're looking to sell it within 2 years. Then you have to open the probate and make sure that there's sufficient funds and run a notice to creditors. But if all those requirements are met, then the house, even though it's kind of through probate because you can't do anything until notice to creditors has been run, if nobody submits a claim and there's no bills that need to be paid out of the proceeds of the house, then the house just passes by operational law, and that transfer, if you will, goes all the way back to when your loved one passed away. So essentially, effective immediately upon the death, you don't have to do an executor's deed. Sometimes you'll see attorneys, we offer that option to draft an executor's deed, but you don't even have to have a deed. If the will says it goes to your loved ones, and the will is probated at the courthouse. All that means is it was submitted to the clerk of court. So now it's a matter of public record, and no funds were needed and notice to creditors was run. Then it transfers as of the date of death to the loved ones. And then you're free to sell it, keep it, renovate it, whatever. Is there a mortgage on it? Well, we've done a separate YouTube video about mortgages and what happens. But the short answer is if there's a mortgage on it, just keep paying the mortgage. They can't force you to refinance if you inherit a house through a will. Okay, federal law says can't make me. Obviously, if you go to sell it, you got to pay off the mortgage, but there's a whole video on that. I'll try to link to it up here or down in the comments. So if you are looking to sell the house, you have to run that notice to creditors in order to transfer effective title within 2 years. So if you're going to sell the house, if you're looking at each other and you go, look, we love mom and dad's house, but it's too much to live there. Maybe it needs work. Maybe it's just the memories without mom and dad. It's just too painful. Either way, if you're going to sell it within 2 years, you have to run notice to creditors, and it won't be sold through the estate unless the money is needed, but you do have to open a full estate so you can run that notice to creditors. The other option, of course, is if there are debts that exceed what the estate has available to it, then you would want to sell it through the estate so that those funds can be used, the debts get paid off, and then all of the remaining funds, assuming that there's excess funds, if the house is worth $250,000, but you've only got a mortgage and bills worth $125,000, and there's 3 of you, then there's $125,000 left over. So you pay your legal fees, and then you guys split the remaining funds, whatever they may be, and there's your inheritance. And oftentimes that's what the family wants to do. So if you're in a situation where you've lost a loved one, or if you've got a house and you want to make sure that it transfers to your loved ones effectively, reach out to the team here at Payne Law. If you're looking to hire us for a probate or you need an estate plan, those consultations are 100% free, and we offer free 30-minute consults so that way we can talk through what your estate planning needs are or whether or not we can assist with a probate. We'd be happy to meet with you. You can give us a call at 336-281-6928, or reach out to us on the web at applepaynelaw.com. We'd be honored to help you. Our goal at Apple Payne Law is to help families navigate life's important decisions and making sure that the work you've done throughout your life or that your loved one has done throughout their life to make sure that their assets get to those to whom they wish to leave them couldn't be more important. And so we are here to help you. We want to take good care of you, and we look forward to meeting with you. Hope this has been helpful. Like and subscribe here on YouTube for more helpful and friendly legal content. And until next time, take care and have a great day.